Matt Guichard, this is No Holds Barred. In today's episode, we're going to talk about powers of attorney, why you need them, why everybody needs them, how things can go wrong if you don't have them. So let's get right into it. What actually is a power of attorney? I'll tell you, there are all kinds of powers of attorney. There are powers of attorney for limited purposes, for health care, financial, all kinds. So let's start out with what we call a general power of attorney. A general power of attorney is a document which, let's say, you want to grant some powers to a loved one. You trust them, you're competent. Let's say, for example, you're an elderly person, trouble balancing your checkbook and taking care of your finances and various things in life, and you have a trusted child that you want to give them some powers. A general power of attorney is a form in which you actually grant them the power to handle all those kinds of things, the same powers that you have. So it doesn't mean you're incompetent. It doesn't mean you have to go into a coma or into a hospital. It's general powers that you can grant to them. I'll give you an example about it. General power of attorney, and people oftentimes download the document. You can download it right off and read it. And that is, it has all these different categories. Sell real estate, handle checking, handle your stocks, make medical decisions. All of these things can potentially be. And at the bottom of the general power of attorney in California, there's a box that you check that says, include them all above. And lots of people are very comfortable doing that with a loved one or a trusted person. Now, that's kind of where the rub comes, because many times we see cases where there has been a general power of attorney granting powers to a certain person, and they take advantage of it. Go down and over time drain a checking account, sell property, do all kinds of things. So very important that if you're going to use that general power of attorney, you give it to a trusted one. Another issue that I often tell people is it calls for giving that power to a particular individual. So if you are an elderly parent or a person just wants to give some power to, let's say, a loved one, give it to one person. Give it to one of your children, for example. And then you can have a backup, which is in the document. But in many cases, we found that if you give it to two different people and they have equal powers to you, perhaps they're fighting among themselves, and decisions can't be made. And the next thing you know, your interests aren't being looked out for as you thought. Let's get into more the kinds of powers of attorney that many people think about or talk about. How many of you have actually been to, let's say, the emergency room, and you're going through some intake and the nurse says, do you have a medical directive? And you're thinking, I understand what that is. And a medical directive is, in effect, a power of attorney. We generally call them a durable power of attorney for health care. And a durable power of attorney under the law in California means that if you are incapacitated, so picture somebody has a durable power of attorney when they're able to handle their affairs and everything good, that power doesn't extend to anyone else but them. They make their own decisions for health care, they do all the same. However, let's say they're in an accident, they're in a coma, and the hospital, we can't make decisions without, well, here's a durable power of attorney for health care that's given to a loved one. Contact that loved one. In many cases, it's a spouse, some cases children, some cases a friend. And that friend can then, or child or spouse, can make decisions for the person who is incapacitated and cannot make decisions for himself or herself. We have the same issue of a durable power of attorney for health care. If somebody has dementia and gets to a point where they're incapable of making decisions. But the durable power of attorney is only something that comes into effect when a person is incapacitated. And when that person is no longer incapacitated, it is no longer valid. So for example, somebody is in a coma after a motor vehicle accident, and eventually they come out of the coma. They're not damaged to the extent that they can't make decisions for themselves. Well, those powers that were given to somebody else are no longer valid. That's a durable power of attorney for health care, or in some cases what we call a medical directive. There's a durable power of attorney for financial reasons, and we actually recommend that people have both. A durable power of attorney for medical, a durable power of attorney for financial. And how would that work? Well, in the same situation. Let's assume that person went into a coma, is no longer competent or is able to make any kinds of decisions. Who pays the rent? Who goes down to the bank and balances the checkbook and makes sure that checks don't bounce? Who makes some financial decisions? Pay the life insurance policy, do all kinds of things. And that durable power of attorney for financial affairs it comes into play. And so somebody can go down to the bank and say, look, here it is, person's incapacitated, and I'm going to do some of these, make these decisions, collect rent, pay rent, do all the various things that need to be done. But again, just as with a durable power of attorney for healthcare, it is no longer a valid document for that person who's received it to make decisions after the person comes out of the coma or finds themselves in a position where they can go back and make their own decisions. The difference between those durables, and that's just a term in California that we use, and a regular power of attorney, a general power of attorney, is the general power of attorney gives those rights whether the person is incapacitated or not. So let's talk a little bit about how things might work when they go wrong. And that is that somebody takes advantage of it. You have too many people are making decisions rather than just one person. And overall, we want to get back, and we'll talk about at another no holds barred show, and we're going to have somebody come in and actually talk about estate planning. So oftentimes in a trust document, an estate planning document, it has essentially the same kinds of languages that we would see in durable powers of attorney for healthcare and financial care. How does that work? Well, let's say that somebody has a trust, and the trust indicates that there's a successor trustee, so that the person either dies or, let's say in this case, develops Alzheimer's, and a doctor attests to it. Oftentimes in that trust document, it will say that it has to have perhaps one or two doctors to attest to the fact that the person is no longer competent. So we've been involved in cases like that where we have looked at trust documents, somebody comes to us, their aunt has Alzheimer's, and now is in a position where she is no longer competent. We engage with her primary care physician or perhaps her neurologist, so she is no longer competent to make any decisions whatsoever. And here we have a trust document that indicates what will happen. Who is the successor trustee? Because in estate planning, when somebody is competent and they have their own trust, they are the trustee of their own affairs. When they're not competent anymore, generally those documents would have what's called a successor trustee. So the successor trustee then steps into the role of that person with all rights after a doctor has attested. Some documents say one or two doctors, and then we actually go to court with that document, and we actually have a motion for the court to declare that in fact the successor trustee steps into the role of the individual and can make all decisions. From that point forward, and I use the term, that successor trustee is the trustee. Bank accounts, selling of property, making all decisions, soup to nuts. And that's kind of very important. But it is the same concept as we have in durable powers of attorney, both for healthcare and not. When we do talk about the powers of attorney, there are certain kinds of specialized ones. And let's say, for example, you own a piece of property in Connecticut. It's a family piece of property, but you haven't been in Connecticut for years, but you want to sell that property, and you don't want to have to travel back to Connecticut. In some cases, you can have a special power of attorney that you grant to somebody, perhaps your real estate agent in Connecticut or some other person, to make decisions only as it relates to the sale of that property. So we have special powers of attorney. And so you can think of lots and lots of situations in which an individual will want to give a special power to accomplish something, but for a very limited purpose. It only lasts as long as the, let's say, the sale of that property in Connecticut. Now, a power of attorney can be revoked. So that's very important. It can be revoked unless it's a durable power of attorney. So you can think again, I don't want to confuse you, but if you have a general power of attorney and you decide, nope, that person I don't trust anymore, there's just something I don't like about it, I'm going to revoke it. So then you have to affirmatively revoke that power of attorney, notify the other party, and revoke it, and perhaps have a new power of attorney naming somebody else, giving somebody else the power. But that's important. But keep in mind that once a durable power of attorney comes into play where the person is not going to come out of that coma or not going to miraculously no longer have end stages of Alzheimer's, that's it. That the person who has those powers will have those powers. And without getting too much into how the estate planning times and the probate times, but you can picture how somebody has a durable power of attorney for financial reasons for their parent. The parent dies or is permanently incapacitated, and all of a sudden the other siblings don't like what the person is doing, and there's a lawsuit in court. And we see that all the time because somebody is saying, well, you have a fiduciary duty to look out for our interests because we are people that could potentially inherit something, and you're not looking out for our interests. So you can see how all these things can come into play, why you want to be very judicious in looking at who you want to name as the person on your power of attorney, who you want to give rights to, and what rights you give to them. At one point, I was a deputy district attorney in Contra Costa County, and I had some control over a unit that actually handled elder financial abuse and actually an elder physical abuse. And we would often see cases in which a person was given some authority in a power of attorney, and they abused that authority, took money for themselves. Now, somebody has, under most trusts, they certainly have the right to be reasonably compensated for what they do. Generally, powers of attorney for healthcare directives or financial don't have a component in which the person that has received those powers is allowed to pay themselves for the work that they do. And you would think that if at some point the durable power of attorney doesn't apply if the person has died, then we look at estate and trust documents. So I suppose the moral of the story is everyone, absolutely everyone, should have a healthcare directive, which is otherwise known as a durable power of attorney for healthcare. And I'll say to you, we had a child who is in college back east, and once she reached 18 years of age, we determined that, goodness, if something were to happen back where she's at college in another state, and she's 18, she's an adult, we would have no ability as her parents to make any medical decisions for her or any decisions for her, in spite of the fact that she's our child. So we prepared and had prepared a durable power of attorney for health care, a medical directive. And before she went to school, we had her, with her certainly consent, and she understood why it was important to do that, sign off on that. In some cases, you have 2 witnesses. In other cases, it's sufficient to actually have it notarized. So in that case, we actually had 2 witnesses, and we had it notarized. And then we had a little bit of a cottage industry to help out a number of our friends who were in a similar situation, explaining to them how important it was to have this medical directive for their children who were off somewhere else and they had no control. So I like people to think about those kinds of things, and that's a little bit of estate planning, thinking about that. Certainly if you're going to go to an attorney and have them help you with estate planning, having the trust prepared, having successor trustees, having a pour-over will, which is if you've forgotten to put something in the trust, pour-over will put it into the trust, and then have those important powers of attorney. The 2 most important under those circumstances, again, durable power of attorney for health care and durable power of attorney for financial decisions. So those are the kinds of things that we often think about, how important those are. But again, the agent, and that's a term that I'll use now, the agent is the person that you're giving power to. Make sure that person is trustworthy, is competent, and interview them and hope that when the time comes, they will make the proper decisions and the decisions that you would want them to make with respect to your own health. And that comes down to even the time of the doctor suggests that you're in such a situation that they recommend it, pulling the plug, as we call it. And with that medical directive or a durable power of attorney for health care, that is a decision that that agent could potentially make. So when the hospital is looking at 4 children of an elderly person, 2 of whom say, oh no, we don't want to pull the plug, and 2 others say, yeah, we're going to pull the plug. Who's the agent? Who's the person who ultimately has the legal ability to make that decision with a legal document that they can show to those at the hospital and at least provide the legal grounds for making the decision to pull that plug? Very important. I do want to say that we've spoken about many powers of attorney. Most people don't know what a power of attorney is, and some people use the term DPOA, and most people's eyes spin in their orbits. What the heck is a DPOA? Well, it's a durable power of attorney. I don't like that term because I do think that it confuses people. I like the term durable power of attorney, or in the healthcare industry, I like a medical directive, but in effect, it's a DPOA is a durable power of attorney. I talked about a major general power of attorney, special powers of attorney. So I guess, again, the moral of this particular part of the story is engage with an attorney. Reach out and discuss these important matters with an attorney who can then guide you as to what kind of power of attorney is best for you and is appropriate for you. Thanks for watching this episode on powers of attorney. Like and subscribe. We look forward to seeing you on the next episode of No Holds Barred.